My business partner and my sister stole my company while I was grieving my father. They didn't know I owned the patent. My name is Margot Ellery, and the worst betrayal of my life happened during the 7 days I was too busy burying my father to notice it was happening. I want to start there, because I think the timing is the part that still makes my chest tighten even now, 3 years later. Betrayal is painful, under any circumstances. Betrayal that is deliberately timed to land while you're too devastated to defend yourself is a different, colder kind of cruelty, and it's the kind of cruelty this story is about. My father, Walter Ellery, was a mechanical engineer who spent 31 years at a mid-sized industrial equipment manufacturer before retiring, and who spent the last decade of his life quietly obsessed with a single idea, a modular water filtration cartridge design that could be manufactured cheaply enough to be genuinely accessible in regions without reliable municipal water treatment, but engineered precisely enough to actually outperform far more expensive commercial systems. He worked on it in our garage on weekends for years, failing, adjusting, failing again, in the specific patient way engineers who actually care about a problem work, rather than the way people in movies dramatically work on inventions. I was the one who helped him finally get it right. I'd studied chemical engineering myself, partly because I grew up watching him tinker, and partly because I genuinely loved the material science underneath what he was trying to do. And by the time I was 28, working alongside him on weekends the way I'd done since childhood, we solved the specific membrane degradation problem that had stalled his design for 6 years. We filed a joint patent together, my name and his name, equal co-inventors. A detail I want you to remember, because it becomes the single most important fact in this entire story. We started a small company together to commercialize it, Ellery Filtration Systems. My father ran operations and relationships with early manufacturing partners, drawing on 3 decades of industry contacts. I ran the technical development and, increasingly, the business side, because my father, brilliant as he was with engineering, had never had much patience for contracts, term sheets, or the specific unglamorous administrative work of actually running a company. 2 years into building the company, we brought on a third person to help scale operations and sales. My younger sister's husband, a smooth, confident man named Desmond Castellan, who had a genuine talent for sales relationships and who, on paper, seemed like exactly the kind of complementary skill set the growing company needed. My sister, Priscilla, joined shortly after in a marketing capacity. I want to be honest and say that at the time, bringing family in felt like a strength, not a vulnerability. I loved my sister. I trusted her husband. I had no reason, in those early years, to believe either of them capable of what eventually happened. I want to give you a fuller picture of my father before I move forward, because I think understanding exactly who he was makes what happened afterward land with the weight it deserves. Walter Ellery was not a flashy man. He drove the same truck for 19 years. He wore the same 3 flannel shirts in rotation for most of my childhood, replacing them only when my mother finally, forcibly retired them to rags. He was the kind of engineer who found genuine, quiet joy in a problem solved elegantly, rather than a problem solved impressively, he used to tell me, standing over his workbench on Saturday mornings while I handed him tools before I was old enough to understand half of what he was building, that the best engineering disappears into the result, it doesn't announce itself. I think about that phrase constantly now, because it describes almost exactly the opposite of how Desmond eventually chose to operate. My father cared, specifically and stubbornly, about clean water access in a way that went beyond professional interest. He'd spent 2 years early in his career working a rotation with an engineering nonprofit in a rural region without reliable municipal treatment, and he came back from that assignment permanently changed, in the specific way people are changed by seeing a solvable problem up close and then spending the rest of their career unable to fully let it go. Every version of the filtration cartridge he built in our garage over that decade was, in some sense, an attempt to finish something that assignment had started in him decades earlier. My father died suddenly, of a cardiac event, 11 days before what would have turned out to be the most important licensing negotiation of the company's history, a potential agreement with a large industrial water treatment conglomerate that would have brought Ellery Filtration Systems from a promising small operation into genuine, life-changing scale. I spent the week after his death doing exactly what any devastated daughter would do, arranging a funeral, managing his estate, comforting my mother, who had been married to him for 38 years and was, understandably, barely able to function. I stepped back from the company entirely for those 7 days, trusting Desmond and Priscilla to hold things steady in my absence, the way you trust family during a crisis. What I didn't know, during those 7 days, was that Desmond and Priscilla were using my absolute absence, my complete emotional and physical disengagement from every decision the company was making, to execute a plan that had, I would later learn, been in motion for months before my father ever died. I need to back up slightly and tell you about the months before my father's death, because the warning signs were there and I missed almost all of them. Not out of naivety exactly, but out of a specific, deliberate choice to trust family over suspicion, a choice I understand completely differently now. Desmond had, over the preceding year, become increasingly involved in what he described as structuring the company for growth, a phrase that sounds reasonable on its surface, and that I now recognize as the exact kind of vague, confidence-projecting language people use when they're quietly reshaping something to their own advantage while making it sound like routine professional housekeeping. Specifically, Desmond had pushed hard, over several months, for the company to formally incorporate with a more sophisticated equity structure than the simple partnership arrangement my father and I had originally set up. He brought in an attorney, one he'd selected, not one I'd vetted independently, a detail that matters enormously in hindsight, who drafted new operating agreements distributing equity across the 4 of us: my father, myself, Desmond, and Priscilla. I remember the conversation where this was proposed. It was at a family dinner, 6 months before my father died, and Desmond framed it as simple fairness. You and your dad have the patent and the founding equity. Obviously, that's not in question. But Priscilla and I have been putting in real hours for 2 years now, and for us to keep growing, investors are going to want to see equity properly reflecting who's actually running day-to-day operations. End quote. My father, who trusted Desmond largely because Priscilla trusted him, and who had never had much appetite for the granular details of equity structuring, agreed readily. I agreed too, more cautiously, but agreed nonetheless, because the actual percentages being proposed, 20% each for Desmond and Priscilla, 30% each for my father and me, seemed reasonable on their face, and because I genuinely didn't want to be the person in the family who treated her own sister and brother-in-law with suspicion over percentage points. I want to describe the specific meeting where this operating agreement was actually signed, because there's a detail I only came to appreciate the significance of much later. It took place at Desmond's attorney's office, in a conference room with all 4 of us present: my father, myself, Desmond, and Priscilla. The attorney walked through the document at a brisk pace, using the specific, confident, slightly bored tone professionals sometimes adopt when they want a room to feel that a document is more routine and less consequential than it actually is. He spent nearly 40 minutes on the sections detailing quarterly distribution formulas and vesting schedules for Desmond and Priscilla's new equity, sections that were, admittedly, genuinely complex and worth walking through carefully. He spent perhaps 90 seconds on the estate succession provisions, describing them only as standard boilerplate, ensuring operational continuity in the event of a founder's incapacity or death. Nothing unusual. Every operating agreement includes something like this. I remember, specifically, my father nodding along during that 90-second summary, the nod of a tired man eager to finish a meeting about paperwork he found tedious and get back to the actual engineering work he cared about. I nodded too, if I'm honest, distracted at the time by my own excitement about an upcoming trade show where we planned to demonstrate the technology to potential new manufacturing partners. Neither of us asked the attorney to slow down, to walk through the specific mechanics of exactly how operational continuity would be determined, exactly whose votes would control that determination, exactly what threshold of ambiguity would trigger the clause's activation. I've relived that specific 90 seconds in that conference room more times than almost any other moment in this entire story, because it's the exact point where a slightly more careful question, a slightly less trusting assumption, could have prevented everything that followed. What I did not fully appreciate at the time, and what I only pieced together in painful detail much later, with the help of an attorney who actually understood corporate structuring, the way Desmond's chosen attorney clearly understood it far better than I did, was a specific clause buried in the new operating agreement regarding what happened to a deceased founder's equity in the absence of a formal, updated estate plan naming a successor. My father, brilliant engineer, terrible administrator, had never gotten around to updating his personal will to reflect the new company structure. Under the operating agreement Desmond's attorney had drafted, in the absence of a specifically named successor for a deceased founder's shares, those shares would default to being managed by a majority vote of the remaining active operational partners, meaning, functionally, Desmond and Priscilla, who together held 40% of the company and who, under this clause, would gain effective control over my father's additional 30% during any period of estate resolution ambiguity, a phrase so bureaucratically bloodless that I don't think my father, reading it in the exhaustion of finalizing paperwork he didn't fully enjoy engaging with, ever understood its actual weight. I signed that operating agreement too, 6 months before my father died, trusting that a document my own father had also signed, drafted by an attorney my own sister had vouched for, wasn't a trap being quietly laid for exactly the circumstance that would, tragically and entirely by coincidence, arrive just 6 months later. My father died on a Tuesday morning. I remember almost nothing about the specific mechanics of that week, the funeral home visits, the obituary drafting, the receiving line at the service, with any real clarity, because grief that acute has a way of making time feel simultaneously endless and completely unrecorded, like a week your brain simply declined to properly save. What I do remember, with total clarity, is a phone call from Desmond on the Thursday of that week, 2 days after my father's death, 3 days before the funeral, in which he told me, in a warm, reassuring voice, that he and Priscilla had got everything handled at the company, that I shouldn't worry about a single thing, that my only job right now was to grieve and be with my mother, and that they'd keep me fully looped in once things settled down. I believed him completely. I want to be honest about that, because I think it's important for anyone listening to this story who has been in a similar position of acute grief to understand there is nothing shameful about trusting family during the worst week of your life. The shame, if there is any to assign here, belongs entirely to the people who exploited that trust, not to the person grieving who extended it. I remember, specifically, standing in the receiving line at my father's funeral, shaking hands with dozens of his old colleagues and engineering friends, many of whom told me, with genuine warmth, how proud he'd always been of the company we'd built together, how he used to talk about the filtration project at industry conferences, with the specific, barely contained enthusiasm of a man who genuinely believed he was close to solving something that mattered. I remember Desmond standing near the back of that same receiving line, in a dark suit, shaking the same hands, accepting condolences, as though he were a co-founder of equal standing in the company's origin story, when in truth, he'd joined 2 years into a project my father had already spent most of a decade building before Desmond ever set foot in our garage. I didn't think much of that discrepancy at the time. Funerals blur people's roles into a single, undifferentiated category of people who cared about him, but I've thought about it often since, because I think it was, in its own small way, an early preview of how completely Desmond was prepared to insert himself into a legacy he hadn't actually built. What Desmond did not tell me during that call, what I would only learn nearly 3 weeks later, once I'd begun, slowly and painfully, to re-engage with the company's operations, was that he had, during that exact week, executed the licensing negotiation with the industrial water treatment conglomerate that my father and I had spent months preparing for, and had done so without me present, without me consulted, and, this is the detail that still makes me physically ill to describe, using the estate resolution ambiguity clause to formally cast my father's 30% voting share alongside his and Priscilla's 40%, giving them, combined, 70% effective control over a licensing decision that would shape the entire future of the company my father and I had actually built together. The deal Desmond negotiated and signed on behalf of Ellery Filtration Systems during that week was structurally very different from the deal my father and I had spent months preparing to negotiate ourselves. Our version had prioritized retaining meaningful ongoing royalty rights and technical control over future product iterations. Understanding that the patent itself, my father's and my joint patent, was the actual core value of the entire company, more valuable in the long run than any single licensing payout. Desmond's version, by contrast, prioritized a much larger upfront cash payment in exchange for signing away far more extensive licensing rights, structured in a way that would have functionally transferred most of the practical commercial value of the technology to the conglomerate for a fraction of its actual long-term worth. I want you to notice something in that structure, because it becomes critical later. Desmond's negotiated deal maximized immediate cash into the company's accounts where he and Priscilla, following the estate ambiguity vote, now held effective majority control over distribution decisions, while systematically undervaluing the actual intellectual property that made the entire company valuable in the first place. In other words, the deal wasn't simply badly negotiated. It was structured, I would come to believe, with real evidence over the following months, specifically to convert a long-term, patent-protected asset that Desmond and Priscilla didn't fully own into a large, immediate cash payout that they very much did have access to control. I found out about the signed deal roughly 3 weeks after my father's funeral, during a period when I was, understandably, still barely functioning, showing up to the office 2 or 3 days a week, mostly to have something to do with my hands and my mind, besides sitting in my father's empty garage workshop, which I hadn't yet been able to bring myself to clean out. Desmond mentioned the deal almost in passing, during what he framed as a routine catch-up meeting, describing it as great news. Honestly, given everything, we landed real capital during a really hard stretch. Your dad would have been proud of how the team held things together. I asked to see the actual signed agreement. Desmond hesitated, barely perceptibly, but I noticed, because grief, I've learned, has a strange way of sharpening your attention to small inconsistencies, even while dulling your attention to almost everything else, before saying he'd have the finalized copy sent over once a few last administrative details were wrapped up. It took me another 11 days of persistent, increasingly pointed requests to actually get a copy of the signed agreement, and when I finally read it in full, sitting alone at my kitchen table late one night, I understood almost immediately, even without full legal training in licensing structures, that something was deeply, badly wrong. The royalty percentages were a fraction of what my father and I had discussed as our floor for negotiations. The scope of licensed rights extended far beyond what any reasonable negotiator would have conceded without extracting significantly more value in return. And buried in a subordinate clause, in language dense enough that I had to read it 4 times before I fully understood its implication, was a provision granting the licensing conglomerate a right of first refusal on any future related patents developed using the same core membrane technology, meaning any future improvement my father and I might have developed together, had he lived, or that I might develop alone going forward, would need to be offered to this same conglomerate first, at terms this same agreement had already established as heavily favorable to them. I called an intellectual property attorney the following morning, not the attorney Desmond had originally brought in, obviously, but an independent specialist named Corinne Adebayo, whom a colleague from graduate school recommended specifically because of her reputation for untangling exactly this kind of family business dispute involving intellectual property. Corinne asked me a single question in our first meeting that reshaped everything that followed. Margot, whose name is actually on the original patent, I told her, mine and my father's, jointly, filed years before the company's operating agreement was ever drafted, years before Desmond or Priscilla had any involvement in the business whatsoever. Corinne's expression shifted in a way I'll never forget, the specific look of a professional recognizing that her client held far more leverage than she'd initially suspected walking into the meeting. She said, "Margot, I need you to understand something clearly, because I don't think Desmond or his attorney fully appreciated this when they structured any of this. A company's operating agreement can absolutely govern how business decisions get made, how revenue gets distributed, even how voting shares get allocated during an estate ambiguity. But an operating agreement cannot unilaterally transfer ownership of a patent that was never actually assigned to the company in the first place, unless there's a specific, properly executed patent assignment document. Did you and your father ever formally assign the patent itself to Ellery Filtration Systems as a corporate asset, separate from simply operating the business under that patent's license? I genuinely didn't know the answer to that question with certainty, and neither, as it turned out, did Desmond's attorney, because it was about to become the single most important unresolved fact in the entire story. Before I move on to the discovery of the patent assignment gap, I want to describe a specific, quieter thing I did during this period, because I think it matters to the emotional shape of the story, even though it wasn't strictly part of the legal strategy. Roughly 2 weeks after I first read the badly negotiated licensing agreement, before I'd even called Corinne, I spent an entire Saturday going through my father's garage workshop for the first time since his death, something I'd been avoiding, partly out of grief and partly, I now recognize, out of a kind of superstitious fear that dismantling the physical space where he'd spent a decade of Saturdays would somehow make his absence more permanently real. I found, in a battered metal filing cabinet in the corner of the workshop, a set of his old lab notebooks, dating back nearly 15 years, documenting every iteration of the filtration cartridge design in his own careful, engineer's handwriting, dated entries, failed prototypes crossed out with brief, unsentimental notes about exactly why each attempt hadn't worked, and, running through all of it, a consistent, almost stubborn optimism that the next iteration would finally solve the membrane degradation problem that had stalled him for years before I joined the project. I sat on the concrete floor of that garage for hours, reading through those notebooks, and I want to be honest that it was, in some ways, more emotionally significant to me than anything that happened later in the legal proceedings, because it reminded me, with total clarity, exactly what the actual thing at stake in this entire conflict was. It wasn't really about equity percentages or licensing royalty rates, however much those numbers eventually mattered practically. It was about a decade of my father's patient, unglamorous work, distilled into a physical object meant to help people who badly needed clean water, and the question of whether that decade of work would end up controlled by people who saw it purely as a vehicle for a quick, maximized cash payout, or would remain in the hands of someone who actually understood and valued what it was originally built to do. I found something else in that filing cabinet that turned out to be unexpectedly useful once the legal proceedings began. A complete, dated paper trail of every design iteration, cross-referenced against my own digital lab records from graduate school, establishing with total clarity the specific timeline of when my father and I had jointly solved the membrane degradation problem that formed the core of the eventual patent, documentation that predated Desmond's involvement in the company by nearly 2 years, and that became, later, useful corroborating evidence for exactly how long the intellectual property at the center of this entire dispute had existed as something my father and I had built together, entirely independent of any structure Desmond later attempted to impose on top of it. I photographed every page of those notebooks that weekend, both out of a practical instinct that they might eventually matter legally, and out of a simpler, more personal instinct that I wanted a permanent, complete record of my father's actual work, preserved carefully, regardless of how the business dispute eventually resolved. I was right about the legal usefulness. I was even more right about the personal significance. Those digitized notebooks are, today, among my most treasured possessions, considerably more meaningful to me than any equity stake or settlement figure that came out of the eventual resolution. Corinne spent the following 3 weeks doing something Desmond's team, in all their confident maneuvering during my father's funeral week, had apparently never bothered to actually verify: a full, formal review of the chain of title on the original patent. What she found changed everything. My father and I had indeed filed the joint patent years before the company existed in its current form. When the company was later formally incorporated, and when the subsequent operating agreement was drafted bringing Desmond and Priscilla into equity positions, the standard, legally necessary step of formally assigning the patent itself, as opposed to simply licensing its use, from my father and me personally into the corporate entity, had never actually been executed. There was no patent assignment document anywhere in the company's official records. Desmond's attorney, in drafting the elaborate operating agreement governing equity distribution and the estate ambiguity clause, had apparently assumed, incorrectly, that incorporating the company and structuring its operating agreement was sufficient to establish corporate ownership over intellectual property that had, in fact, never been formally transferred at all. I want to describe the specific moment Corinne first explained this to me clearly, because it's one of the few genuinely hopeful moments in an otherwise difficult year, and I think it deserves to be told with the weight it carried at the time. We were sitting in her office, surrounded by printouts of the patent filing history, the operating agreement, and correspondence records she'd spent weeks compiling. She pulled up the original patent filing on her monitor, turned it toward me, and pointed to the inventor field, where my father's name and mine sat side by side, exactly as they had for years. "Margot," she said, "I need you to really understand what this means, because I don't think you've let yourself believe it yet. Every single dollar this company has ever made, every licensing deal, every distribution to Desmond and Priscilla, every bit of the 70% voting control they used to push through that deal during your father's funeral week, all of it depended entirely on continued access to a piece of intellectual property that legally belongs to you, and, through inheritance, to you alone now. They built an entire structure of control on top of an asset they never actually secured. It's like watching someone spend years elaborately renovating a house, adding rooms, changing the landscaping, installing an expensive security system, without ever realizing they never actually finalized the purchase of the land underneath it. I remember sitting with that explanation for a long moment before I fully absorbed it, and I remember the specific physical sensation of something shifting in my chest. Not joy exactly. Grief doesn't simply evaporate because a legal advantage appears, but something closer to the return of solid ground beneath feet that had been standing on uncertain footing for months. For the first time since my father's death, I felt something other than pure grief and pure anger. I felt, cautiously, the early outline of a path forward that didn't depend on anyone else's mercy or goodwill. This meant something extraordinary, something I don't think anyone besides Corinne and I fully understood for several more weeks, while we quietly confirmed every detail before acting. My father and I, personally, as individuals, had remained throughout this entire time the actual legal owners of the patent underlying every product Ellery Filtration Systems had ever sold or licensed. The company had been operating under an implicit, informal license from us, reasonable and appropriate during the years when my father and I were the company's clear controlling founders, but suddenly, dramatically significant now, that Desmond and Priscilla had attempted to use an equity and voting structure to seize control over licensing decisions regarding technology they had never actually, formally, legally owned any rights to independent of our continued informal cooperation. Following my father's death, his 50% interest in the jointly held patent passed, under his actual, valid personal will, which, crucially, unlike the company's operating agreement, he had kept properly updated over the years, specifically regarding his personal intellectual property, a detail I hadn't fully appreciated the significance of until Corinne walked me through it. Directly to me, his sole heir regarding that specific asset, since my mother had, years earlier, explicitly and knowingly waived any personal claim to the patent in the couple's own estate planning, understanding it as fundamentally Walter and Margot's project rather than a joint marital asset. In other words, I now personally, individually, owned 100% of the actual patent underlying the entire value of Ellery Filtration Systems. Desmond and Priscilla owned, through their equity stakes and their opportunistic use of the estate ambiguity clause, meaningful operational and voting control over the company entity itself. But the company entity, it turned out, had never actually owned the intellectual property that made it valuable in the first place. They had built an elaborate structure to seize control of a house, without realizing they'd never actually acquired the deed to the land it was sitting on. I want to describe the weeks immediately following this discovery, because I think the restraint I exercised during this period is one of the most important parts of the entire story, and it's a pattern I've come to recognize in other accounts of betrayal like mine. The temptation to act immediately, out of righteous anger, is enormous, and resisting that temptation in favor of careful, complete preparation is almost always the more powerful choice in the long run. Corinne advised, and I fully agreed, that revealing what we'd discovered immediately, confronting Desmond and Priscilla with the patent assignment gap the moment we'd confirmed it, would give them time to scramble, to attempt some retroactive fix, to potentially even destroy or alter records before I had fully secured my position. Instead, we spent nearly 2 additional months, quietly, methodically building an airtight case, formally, properly reconfirming and re-registering my full, undisputed ownership of the patent following my father's estate settlement, documenting, in detail, every instance where the company had continued operating under the technology without a valid corporate assignment. And this part required real professional discipline on my part, continuing to show up at Ellery Filtration Systems offices during this period, participating in meetings, maintaining the appearance of a grieving, somewhat disengaged minority partner, slowly finding her footing again after her father's death, while privately holding knowledge that would eventually unravel everything Desmond and Priscilla believed they'd successfully seized. I want to be honest about how emotionally difficult this period was, because I don't want to make it sound like a purely strategic, bloodless exercise. Sitting across a conference table from my own sister, week after week, watching her discuss our company's future, with a confidence built on a foundation she didn't realize was hollow, while I said nothing, revealed nothing, and simply gathered more evidence. That took a genuine, exhausting emotional toll, layered directly on top of grief for my father that I hadn't even begun to properly process. There were nights during that period when I questioned whether the patience was worth it, whether I should simply confront them immediately and let the consequences unfold however they unfolded. Corinne, and eventually my own careful reflection, kept bringing me back to the same conclusion. Acting from incomplete strength, out of impatience, risked losing leverage I could never fully recover. Acting from complete strength, once fully documented and secured, meant I would only need to act once, decisively and correctly. During this period, I also learned something additional that deepened the betrayal considerably. Priscilla, I discovered through documents Corinne's investigation surfaced, had known about the patent assignment gap for at least several weeks before I did. An email exchange between Priscilla and Desmond's attorney, obtained properly through the discovery process once formal legal action eventually began, revealed that the attorney had flagged the missing assignment as a technical gap we should probably clean up at some point, nearly a year before my father's death, and that Priscilla had responded, in writing, suggesting they not draw unnecessary attention to it for now since things are working fine as they are. Reading that email was, I'll admit, more painful in some ways than discovering the original licensing deal itself. It confirmed something I had been unable to fully accept until I saw it in her own handwriting. My sister had known, for the better part of a year, that the entire structure Desmond had built rested on a legal gap that could unravel everything, and rather than correcting it or telling me, she had chosen to quietly let it remain, presumably believing it would never actually surface, or perhaps simply not caring whether it eventually hurt me, as long as it didn't inconvenience their control in the meantime. I want to describe one more specific memory from this waiting period, because I think it captures the particular texture of grief layered on top of betrayal better than any general summary could. About 6 weeks into the quiet evidence-gathering phase, before I'd revealed anything to Desmond or Priscilla, my mother called me one evening, worried, asking why I seemed so distant lately, why I hadn't been returning her calls as quickly as usual. I remember sitting in my car in my own driveway, engine off, unable to make myself go inside, trying to figure out how to explain to my grieving, exhausted mother that her younger daughter and son-in-law had exploited her husband's death to seize control of the company he'd spent a decade building, without that explanation landing as one more devastating loss stacked directly on top of the one she was already struggling to survive. I decided, in that moment, not to tell her yet, a decision I still believe was correct, though it meant carrying the full emotional weight of the betrayal essentially alone for several additional months, unable to share it with the one person whose comfort I most wanted, precisely because sharing it risked making her own grief immeasurably worse before I had anything resolved enough to offer her real reassurance alongside the difficult news. That specific kind of isolation, knowing something devastating and choosing silence, not out of strategy alone, but out of genuine care for someone else's fragile state, is, I think, one of the least discussed costs of navigating a betrayal like this. It isn't just the betrayal itself that exhausts you. It's the loneliness of carrying the knowledge of it while still performing normalcy for everyone around you who isn't yet ready to bear its weight. I want to describe one more scene from the period before we sent the formal legal letter, because I think it's the moment I finally understood, without any remaining doubt, exactly what kind of person Desmond actually was, beneath the confident, charming exterior I'd known for 3 years. About a week before Corinne and I finished the formal legal notice, Desmond invited me to dinner. Just the two of us, he said, to catch up properly, since it's been a hard year, and we haven't really talked, in a long time. I almost declined. Something about the timing felt calculated, though I couldn't yet articulate exactly what. I decided to go anyway, partly out of curiosity about what he actually wanted, and partly because I recognized that observing his behavior directly, without Priscilla present to soften or reframe anything, might give me useful insight before we sent the letter. The dinner started innocuously enough, with Desmond asking genuine-seeming questions about how I was holding up since my father's death, questions I answered honestly, still not yet revealing anything about what Corinne and I had discovered. About halfway through the meal, though, his tone shifted, subtly at first and then more directly. He mentioned, seemingly casually, that he'd heard through a mutual industry contact that I'd been asking around about intellectual property attorneys, and wondered, with a smile that didn't quite reach his eyes, whether there was something specific I was concerned about that he could help address directly, as family, rather than getting lawyers unnecessarily involved in what's really just an internal matter. I recognized, in that moment, exactly what the dinner actually was, not a genuine attempt to reconnect, but a reconnaissance mission, an attempt to gauge how much I'd already discovered before I'd formally revealed anything, and simultaneously, an attempt to frame any eventual legal action I might take as an unnecessary betrayal of family trust, positioning himself, preemptively, as the reasonable party and me as the one escalating unnecessarily. I told him, carefully, that I was simply doing my own due diligence on the company's structure now that I was more actively involved again following my father's death, standard practice for any founder returning to closer engagement with a business. He pressed further, more directly this time, asking whether I'd found anything concerning in my review. I told him, honestly but without revealing the specific discovery, that I was still in the process of understanding everything fully and would discuss any concerns through the appropriate channels once I had. His expression, in the specific pause that followed that answer, told me everything I needed to know. It wasn't anger exactly, and it wasn't panic. It was the particular, controlled recalculation of a man who had just confirmed his instinct that something had gone wrong with his plan, without yet knowing the full scope of how badly. He shifted the conversation shortly after to lighter topics, and we finished the dinner with the strained, performative cordiality of two people both aware that something had fundamentally changed between them, neither yet willing to name it directly. I drove home from that dinner and called Corinne immediately, describing the entire conversation in detail. She listened carefully and then said something that reinforced exactly the strategy we'd already been pursuing. Margot, that dinner confirms he already suspects you know something, which means he's likely already starting to think about his own defensive positioning. We need to move faster than we might have otherwise, precisely because he now has a head start on preparing his own response. That conversation accelerated our timeline for sending the formal legal notice by nearly 3 weeks, a decision that, in hindsight, I believe meaningfully strengthened our position by preventing Desmond from having as much additional time as he might otherwise have had to attempt some retroactive fix to the patent assignment gap before we'd formally documented and asserted my position. Once Corinne and I had fully secured and documented my position, formal confirmation of the patent's chain of title, complete documentation of the company's operations occurring without valid corporate assignment, and a full accounting of the licensing deal Desmond had executed during my father's funeral week, we made our first move. Corinne drafted, and I personally reviewed and approved every word of, a formal legal notice sent to Ellery Filtration Systems Board, meaning, at that point, Desmond and Priscilla, informing them that the underlying patent had never been properly assigned to the corporate entity, that I, as sole surviving co-inventor and sole heir to my father's interest, was the exclusive legal owner of the intellectual property the company had been operating under, and that, effective immediately, the company's continued use of that patent, including honoring the terms of the licensing agreement Desmond had executed during my father's funeral week, required my explicit, formal authorization I was, at that specific moment, declining to provide, pending a complete renegotiation of my own position within the company. I want to describe the day that letter was delivered, because it's one of the moments in this entire story I've replayed most often in my memory, not with cruelty, but with a kind of quiet, hard-won satisfaction I think anyone who has ever been genuinely, deliberately underestimated will understand completely. Desmond called me within 40 minutes of the letter's delivery, his voice carrying a controlled panic I had genuinely never heard from him before in the 3 years I'd known him. He said something along the lines of, "Margot, I think there's been some serious miscommunication here. This letter seems to be suggesting something that surely can't be accurate. We need to sit down immediately and sort this out as a family." I said calmly, in a voice I'd practiced with Corinne specifically for this moment, "Desmond, there's no miscommunication. Everything in that letter has been independently verified by legal counsel and is fully documented. I'm happy to sit down, but I want to be clear about what that conversation is actually going to be about. It's not going to be about whether the patent assignment gap exists, because it does, verifiably. It's going to be about what happens now that it does." Priscilla called an hour after that, and I want to describe that call specifically, because it was, emotionally, the hardest conversation of the entire ordeal. She didn't lead with strategy or negotiation the way Desmond had. She led with what felt, in the moment, like genuine hurt, saying things like, "Margot, how could you do this to family, especially right now, especially so soon after Dad?" A framing that I recognized, even through my own genuine emotional turmoil, as a deliberate attempt to make me the villain of a story she and her husband had actually authored, using my father's death as the specific window of vulnerability to execute their plan in the first place. I told her, as calmly as I could manage while my hands were shaking, "Priscilla, I know about the email. I know you knew about the patent gap nearly a year before Dad died, and I know you told Desmond's attorney not to draw attention to it. Don't tell me this is about family loyalty when you had a year to tell me the truth and chose silence instead, during exactly the window when telling me the truth would have actually mattered." She didn't have a response to that. The call ended shortly after, and it would be nearly 4 months before Priscilla and I spoke again directly, rather than through attorneys. I want to describe the rest of that day, because it's one of the more emotionally exhausting days of the entire ordeal, even though nothing legally significant happened in it, beyond the 2 phone calls I've already described. After hanging up with Priscilla, I sat alone in my apartment for hours, unable to focus on anything, cycling repeatedly between a kind of grim satisfaction at finally having asserted my position after months of quiet preparation, and a fresh, raw grief at the specific finality of having named the betrayal directly to my own sister, out loud, in a way that couldn't be walked back or reinterpreted more charitably afterward. My mother called that evening, and I made the decision, in that moment, not yet to tell her what had happened, largely because I hadn't yet decided how much detail to share, and didn't want to deliver a partial, confusing version of events that would only generate more anxious questions I wasn't ready to answer. I told her, honestly but incompletely, that there was some complicated business stuff going on with the company that I was working through with a lawyer, and that I'd explain everything fully once it was more resolved. She, still deep in her own grief and exhausted in a way that made her willing to accept a vague explanation without pressing further, said only that she trusted me to handle it and that she loved me. I remember hanging up that call and crying harder than I had at any point since the actual funeral, not from sadness about the business dispute specifically, but from the accumulated weight of holding so much difficult information alone, unable yet to share the full truth with the one parent I had left. What followed was roughly 7 months of formal negotiation, mediated primarily through attorneys, though with several direct sessions where all parties were present, structuring what would ultimately become a complete restructuring of Ellery Filtration Systems' ownership and control. I want to walk through the shape of this negotiation carefully, because I think the specific leverage points matter for understanding how someone in a genuinely weaker initial position, a grieving, minority equity holding daughter, up against a confident brother-in-law and sister who had successfully executed an opportunistic seizure of operational control, can still achieve a dramatically different outcome through patient, well-documented preparation. Desmond's initial negotiating posture was, unsurprisingly, aggressive. His attorney argued that, even without a formal patent assignment, the company had operated in good faith reliance on an implied license from the original inventors for years, that unwinding this relationship now, particularly given the already signed licensing deal with the industrial conglomerate, would create enormous legal and commercial chaos, and that the reasonable, family-oriented path forward would be for me to formally, retroactively assign the patent to the company in exchange for a modestly improved equity position, but continued acceptance of Desmond and Priscilla's operational control. Corinne's response, which I fully endorsed, was direct. There was no obligation whatsoever for me to retroactively assign anything, particularly not to a company whose current leadership had demonstrably exploited a period of acute personal grief to seize control they otherwise would never have obtained, and whose leadership had, per the email evidence, known about the underlying legal vulnerability for nearly a year without disclosure. If Desmond and Priscilla wished to continue operating any business using the patented technology going forward, that would require a completely fresh negotiation, on my terms, reflecting my actual, undisputed ownership position. I also want to describe the specific external pressure that developed during this period, because it significantly strengthened my position beyond what Corinne and I could accomplish through legal argument alone. Word of the dispute, carefully, appropriately disclosed by Corinne through proper legal channels rather than any improper leak, but disclosure that nonetheless became relevant to third parties with a stake in the outcome, reached the industrial water treatment conglomerate that had signed the original licensing deal with Desmond during my father's funeral week. Their own legal team, upon learning that the underlying patent's ownership was now in active dispute and that the company purporting to license it to them may never have actually held valid rights to do so, grew immediately, seriously concerned about the enforceability of their own multi-million-dollar licensing agreement. This external pressure transformed the negotiation completely. Suddenly, Desmond and Priscilla weren't simply negotiating with me over internal company control. They were facing the very real possibility that their signature licensing deal, the deal Desmond had rushed through during my father's funeral week, specifically to lock in a large upfront cash payment before I could meaningfully object, might collapse entirely if the underlying ownership dispute wasn't resolved cleanly and quickly, potentially exposing the company to significant liability for having represented rights it may not have actually possessed. I want to describe one particular negotiation session in detail, because it's the moment I think of as the true turning point in the entire 7-month process. It took place roughly 4 months in, at a conference room in Corinne's office, with Desmond's attorney present alongside Desmond himself, and, separately represented by her own counsel by that point, Priscilla. Desmond's attorney opened that session by attempting a new argument, one they hadn't raised before, that even if the patent assignment gap was real, my continued participation in the company for years, attending meetings, contributing technical work, accepting distributions, constituted implicit ratification of the company's operational structure, including its authority over licensing decisions, regardless of the formal paperwork gap. Corinne's response to this was, I think, the single sharpest moment of legal strategy in the entire ordeal. She said, calmly, implicit ratification requires that the ratifying party have full knowledge of the material facts being ratified. Margot did not have knowledge of the patent assignment gap because your own client's team specifically chose not to disclose it, as evidenced by the email we've already entered into this negotiation. You cannot simultaneously argue that my client should be bound by ratification of a structure whose critical defect was deliberately concealed from her. That's not ratification. That's the textbook definition of fraudulent concealment. And if you'd like to continue down this argument, I'm happy to formally amend our position to include that claim explicitly, with the damages exposure that would bring. The room went quiet after that in a way I recognized. The same specific quiet I'd experienced weeks earlier when Desmond first called me in a panic after receiving our initial letter. Desmond's attorney asked for a recess. When negotiations resumed 40 minutes later, the entire posture had shifted, and within that same session, the broad shape of the eventual settlement began to take form for the first time. I also want to describe the specific moment Priscilla, through her own counsel, finally acknowledged direct knowledge of the concealment, because it's a moment I still think about often. Her attorney, clearly having advised her that continuing to deny knowledge in the face of the email evidence was no longer a credible strategy, had her issue a brief, formal statement acknowledging that she had known about the patent gap prior to my father's death and had not disclosed it to me. She did not apologize in that statement. It was legal language, careful and bloodless, designed to satisfy a negotiating requirement rather than express genuine remorse. I remember hearing that statement read aloud, a strange combination of vindication and fresh grief. The vindication of finally having the concealment acknowledged formally and on the record, and the grief of understanding, with total finality, that this acknowledgement was coming from a place of legal necessity rather than any genuine reckoning with what she'd actually done to me. The final settlement, reached after 7 months of increasingly one-sided negotiation, restructured Ellery filtration systems entirely. I retained full, undisputed personal ownership of the underlying patent, licensed to a newly restructured entity under terms I controlled, including meaningfully improved royalty rates that finally reflected something closer to the technology's actual long-term value rather than the undervalued terms Desmond had originally negotiated. I also received a controlling majority equity position in the restructured company itself, 60%, reflecting both my original founding equity and additional compensation negotiated specifically to account for the exploitation that had occurred during my father's funeral week. Desmond's operational role was eliminated entirely. His attorney had, in the final analysis, badly overreached in constructing a structure that assumed corporate ownership of intellectual property that had simply never been properly secured, and the consequences of that overreach fell, appropriately, on the person who had orchestrated it. Priscilla retained a modest minority equity position. I chose not to eliminate her interest entirely, despite Desmond's role, because I still, even after everything, could not bring myself to sever every remaining thread connecting me to my only sister, but relinquished any operational authority over the company going forward. I want to also mention the financial penalty structure we negotiated, specifically regarding the original licensing deal Desmond had rushed through during the funeral week. Because that deal had been executed using a voting structure built on the estate ambiguity clause, a clause whose exercise, we successfully argued, constituted a breach of fiduciary duty given the timing and the underlying concealment. Desmond personally, rather than the company itself, was held liable for a portion of the value gap between the deal he'd actually negotiated and a reasonable, good faith estimate of the deal my father and I would have negotiated had we been properly consulted. That personal liability, secured through the settlement rather than a full trial, represented a meaningful financial consequence that Desmond bore individually, separate from whatever equity he retained or lost in the company itself. I want to pause the business narrative here and talk honestly about the emotional aftermath of all of this, because I think stories like mine sometimes rush too quickly toward the satisfying resolution and skip over the genuinely difficult, unresolved feelings that remain even after a legal and financial victory. I did not feel triumphant when the settlement finalized. I felt, mostly, exhausted, and beneath the exhaustion, a grief that I realized, once the adrenaline of the legal fight finally subsided, I had never actually allowed myself to properly process regarding my father's death itself. I had spent nearly a year so completely consumed by legal strategy, patent documentation, and negotiation preparation that I had, in a real sense, deferred my own mourning, channeling every ounce of emotional energy into building an airtight case rather than sitting with the simple, devastating fact that my father was gone. I want to be honest that once the legal fight concluded, that deferred grief arrived all at once, in a way that was genuinely difficult to navigate. I spent several months in therapy specifically working through both the loss of my father and the layered betrayal of watching my sister and brother-in-law exploit that loss for their own benefit, a combination of griefs that my therapist described, accurately I think, as compounded loss, not simply losing a parent, but losing, simultaneously, the assumption that the people closest to you will protect you during your most vulnerable moments rather than exploit them. My relationship with Priscilla has not recovered, not fully, even 3 years later. We speak occasionally, briefly, mostly around our mother's birthday or major family events. Neither of us wants to make more painful for our mother by refusing to attend together. But the specific trust that existed between us before all of this, the trust that let me believe, without question, that bringing family into my business was a strength rather than a vulnerability, has not returned, and I've made peace, slowly and with real effort, with the possibility that it may never fully return. I don't say this with bitterness, exactly. I say it because I think honesty about the lasting cost of betrayal, even betrayal you've successfully overcome, matters more than pretending a clean legal victory erases every emotional consequence. Desmond and Priscilla eventually divorced, roughly a year and a half after the settlement, for reasons I understand were largely unrelated to the business dispute itself, though I won't pretend I don't wonder sometimes whether the strain of what happened, watching a plan they'd built together, collapse so completely, so publicly within our small industry circle, contributed to underlying tension that had perhaps already existed in their marriage before I ever discovered the patent gap. I don't know the full truth of that, and I've made a deliberate choice not to ask, because it isn't, in the end, my business. I want to describe the moment I finally told my mother the full truth of what had happened, because it's one of the more emotionally complicated scenes in this entire story, and I don't want to leave it out simply because it doesn't resolve as cleanly as the legal proceedings did. I waited until roughly 2 weeks after the settlement finalized, once there was nothing left uncertain for her to worry about, once I could tell her the whole story with a clear, resolved ending rather than an open wound she'd have to sit with for months, not knowing how it would turn out. She cried for a long time after I finished, and then she said something I've carried with me since, something that reframed the entire ordeal for me in a way even Corinne's legal strategy never quite had. She said, "Your father used to worry near the end that he'd never properly taught you or your sister how to actually protect the things you build, because he never had to learn that lesson himself. His own work was never valuable enough, for most of his career, for anyone to bother trying to take it from him. I think some part of him would be devastated by what Priscilla did. But I also think he'd recognize, in exactly how carefully and patiently you fought to get it back, the very specific kind of engineer's mind he spent your whole childhood trying to pass on to you. The mind that doesn't panic when something breaks, that just quietly, methodically figures out exactly where the structural flaw is and fixes it properly, instead of just patching over the symptom. I don't think I've ever received a piece of comfort, in the entire span of that difficult year, that meant more to me than that specific comparison to my father's way of thinking. Before I move into how I rebuilt the company, I want to describe one specific conversation with Priscilla that happened roughly a year after the settlement, because I think it's the moment that most honestly captures where our relationship actually landed, rather than either a clean reconciliation or a permanent dramatic estrangement, the truth, as it usually is, sitting somewhere messier and more ordinary in between. Priscilla reached out, unprompted, asking if we could meet for coffee, just the two of us, away from our mother, away from any attorneys, away from any remaining business entanglements. I almost said no. I sat with the invitation for nearly a week before responding, genuinely uncertain whether I had the emotional capacity to sit across from her without either shutting down completely or saying something I'd regret. Eventually, I agreed. mostly because I realized that avoiding the conversation indefinitely wasn't actually protecting me from anything. It was just delaying a reckoning I needed to have with my own feelings about her, regardless of whether the conversation itself went well. We met at a small cafe neither of us had any particular history with, deliberately neutral ground. Priscilla looked, I remember thinking, older than I expected. Not literally, only a year had passed, but there was a specific tiredness in her face that hadn't been there before, the tiredness of someone who has spent a year living with the consequences of a choice she can't undo. She didn't start with an apology, not immediately, and I respected that more than I expected to, because I think an immediate, rehearsed-sounding apology would have felt hollow given everything that had happened. Instead, she started by trying to explain, as honestly as she seemed capable of, how she'd arrived at the decision to stay silent about the patent gap. She told me that in the months before our father's death, she and Desmond had been under significant financial strain of their own, struggles she'd never previously shared with me, involving debt from an earlier failed business venture of Desmond's that she'd only partially been aware of when they married. She said the equity restructuring, the push for greater operational control, had started, in her mind at least, as a genuine attempt to secure their own financial stability rather than any calculated plan to exploit our father's eventual death. She said that by the time she learned about the patent gap, nearly a year before he died, she'd already convinced herself that disclosing it would jeopardize the entire structure they'd built, structure she and Desmond had, by that point, become financially dependent on. I listened to all of this without interrupting, the way I'd learned to listen carefully during the entire ordeal, gathering information before responding, rather than reacting immediately. When she finished, I told her honestly what I thought, that I believed her explanation of how the situation began, the genuine financial pressure, the incremental nature of the initial decisions. But I told her, just as honestly, that understanding how someone arrives at a choice doesn't erase the weight of the choice itself, particularly not when that choice specifically involved staying silent during the exact week I was least equipped to protect myself. A week when a single sentence from her, Margot, there's a gap in the patent paperwork you should probably look at before anything major gets signed, would have prevented nearly a year of devastating conflict entirely. She cried during that part of the conversation, and I want to be honest, that some part of me, the part that had grown up idolizing my older sister before any of this happened, wanted desperately to simply forgive her completely in that moment, to let the tears be enough. But I'd learned, over the preceding year, to distinguish between genuine remorse and the specific kind of emotional overwhelm that arrives when someone finally has to sit with the consequences of a choice they'd spent a long time not fully looking at directly. I told her that I appreciated her honesty in that conversation, that I didn't want to permanently sever our relationship, but that rebuilding trust after something this significant wasn't something a single coffee conversation could accomplish, however honest it was. I told her it would take years, if it happened at all, and that it would need to be built the same way I'd rebuilt the company itself, slowly, through consistently observed behavior over time, rather than through any single gesture, however sincere. We hug awkwardly at the end of that conversation, the specific awkward hug of two people who love each other genuinely, but no longer know exactly how to occupy the same emotional space they used to share so easily. We've had a handful of similarly honest, difficult conversations since, spaced months apart, each one slightly easier than the last. I wouldn't describe our relationship today as fully repaired. I would describe it as slowly, deliberately being rebuilt, on a foundation considerably more honest than the one that existed before any of this happened, which is, I've come to believe, probably the most realistic outcome available to us, and possibly a healthier one than the unquestioning closeness we shared before, which turned out to have been resting on assumptions about each other's character that neither of us had ever actually tested under real pressure. I want to spend some time describing what I actually did with the company once I regained meaningful control, because I think the most satisfying part of this entire story, at least for me personally, isn't the legal victory itself, but what I built afterward with the position that victory secured. I renegotiated the licensing agreement with the industrial water treatment conglomerate entirely, once the ownership dispute resolved. Their team, understandably eager to secure clean, undisputed rights after the uncertainty of the previous year, agreed to terms considerably more favorable than Desmond's original deal: improved royalty rates, retained rights for me to license the technology to additional partners in specific international markets. Desmond's original deal had signed away entirely, and, critically, the removal of that troubling right of first refusal clause that would have locked any future improvements to the technology into an unfavorable relationship with a single conglomerate indefinitely. I also did something my father, I believe, would have specifically wanted. I redirected a meaningful portion of the improved licensing revenue toward exactly the mission that had originally motivated his decade of garage tinkering. We established a formal program providing the filtration technology at significantly reduced cost to nonprofit organizations working on water access projects in regions without reliable municipal treatment infrastructure, the original problem my father had spent a decade trying to solve, before the business side of things ever became complicated by anyone's greed, including, in a sense, my own initial willingness to prioritize scale and licensing value over the simpler mission that had started it all. The company today, 3 years after the settlement, is meaningfully larger and more profitable than it ever was under Desmond's brief period of operational control, not because I'm a more brilliant business person than he is, but because I finally had the space, once the legal fight concluded, to run the company according to the values my father and I had actually built it around, rather than according to a structure designed primarily to extract maximum immediate value, regardless of long-term technology or mission integrity. I want to walk through some of the specific changes I made during the first year after regaining control, because I think they illustrate concretely what it actually looks like to rebuild something after a betrayal of this scale, rather than simply describing the rebuilding in vague, feel-good terms. The first thing I did was conduct a complete audit of every decision made during the period of Desmond and Priscilla's operational control. Not out of vindictiveness, but because I genuinely didn't know what other structural problems might be hiding beneath the surface, given what we'd already found with the patent assignment. That audit turned up 2 additional concerning issues: a vendor contract that had been quietly renegotiated to route a meaningful referral fee to a company Desmond's brother owned, a detail nobody besides Desmond had apparently reviewed closely enough to question, and a pattern of delayed, minimized reporting to our early investors regarding the company's actual technical roadmap, apparently intended to keep those investors patient and uninformed, while Desmond consolidated control rather than actively developing the technology further. Neither of these secondary issues rose to the level of the patent situation in terms of legal consequence, but together they painted a clear picture of a leadership style built on quiet self-dealing and information control, rather than the transparent, technically rigorous culture my father had always insisted on. I rebuilt our investor relationships personally, one by one, over several months, being scrupulously honest about exactly what had happened: the funeral week, the patent gap, the settlement, rather than attempting to minimize or spin the story. I want to say that this honesty was, in the short term, professionally uncomfortable. Several investors asked pointed, uncomfortable questions about how such a significant structural gap in our intellectual property could have gone unnoticed for years. I answered those questions directly rather than defensively, and I found, somewhat to my surprise, that most investors respected the transparency considerably more than they would have respected a polished, evasive explanation. 2 investors did eventually choose not to continue their involvement, which I understood and didn't contest. The remaining relationships, I believe, are stronger today than they would have been had I never gone through this ordeal, precisely because those investors watched me handle an extraordinarily difficult situation with documented integrity rather than panic or spin. I also made a specific decision, early in the rebuilding process, to bring on a new operational partner, not family this time, deliberately, a woman named Adaeze Nwosu, a supply chain and manufacturing specialist, with 2 decades of experience scaling exactly the kind of mid-size industrial technology company Ellery Filtration Systems was trying to become. I want to be honest that bringing on a new senior partner after everything that had happened with Desmond required real, deliberate effort to overcome my own instinctive wariness. Adiaze and I spent nearly 4 months in a formal advisory relationship before I offered her any equity position, specifically so I could observe her judgment, her transparency, and her handling of difficult information over an extended period before extending the kind of trust that Desmond had so thoroughly abused. That caution, I believe, was the correct lesson to take from everything that happened, not never trust anyone again, which would have made rebuilding the company impossible, but verify trust patiently through observed behavior over time, rather than extending it automatically simply because someone shares your last name or your family's holiday table. Under Adiaze's operational leadership and my technical and strategic direction, the company expanded its manufacturing partnerships into 2 additional states over the following 2 years, more than doubled its revenue compared to its best year under Desmond's brief control, and, this is the achievement I'm genuinely proudest of, launched the nonprofit water access program I mentioned earlier, which has, as of this recording, provided filtration systems to communities in 4 countries without reliable municipal water treatment, at a cost structure that would never have been financially viable under the licensing terms Desmond originally negotiated, precisely because those terms had signed away so much of the technology's long-term value for a single upfront payment. I kept the company's name unchanged, Ellery Filtration Systems, deliberately, because I wanted my father's name to remain attached to something that, despite everything that happened, ultimately succeeded in doing exactly what he'd always hoped it would. I want to describe one specific moment from the launch of the nonprofit water access program because it's the moment that, more than any legal victory, felt like genuine closure to me. We shipped our first large batch of filtration systems to a partner nonprofit organization operating in a rural region that had struggled for years with unreliable municipal water treatment infrastructure, very similar, as it happens, to the region my father had worked in decades earlier, during the assignment that originally shaped his lifelong interest in this problem. I traveled with our small team to help oversee the initial installation, something I hadn't strictly needed to do personally, but wanted to, for reasons I think anyone who has lost a parent while fighting to preserve their legacy will understand completely. I remember standing at the edge of a small community gathering point, watching local technicians we'd trained install the first cartridge system, watching clean water actually flow from a tap that had previously produced water requiring extensive, expensive treatment before it was safe to drink. An elderly woman from the community, through a translator, thanked our team and asked, out of simple curiosity, how the technology had been developed. I told her, briefly, about my father, about a decade of Saturdays in a garage, about a decade of failed prototypes before he finally solved the problem that had stalled him for years. I didn't tell her about Desmond, about the funeral week, about any of the betrayal that nearly prevented this exact moment from ever happening. That part of the story felt, in that specific setting, genuinely beside the point. What mattered, standing at that tap, watching clean water flow into a container a child was holding steady with both hands, was simply that the thing my father spent a decade trying to build had finally, actually reached someone who needed it. I cried during that visit, quietly, standing slightly apart from the rest of our team, in a way I hadn't allowed myself to cry since the earliest weeks after my father's death. It wasn't sad crying, exactly, though grief was certainly present in it. It was the specific, overwhelming relief of watching a promise finally kept, after a year of fighting so hard simply to preserve the chance of keeping it at all. I don't think this story is really about patents or licensing deals, or even, in the end, about revenge, though I understand completely why it might read that way on the surface. I think it's about something that took me a long time to fully articulate, even to myself, over these 3 years, the specific, particular vulnerability of grief, and how thoroughly some people are willing to exploit it. Desmond and Priscilla's fundamental miscalculation wasn't simply greed, though there was certainly plenty of that. It was the assumption that my grief would be permanent in a specific, useful way, that I would remain too devastated, too disengaged, too trusting of family to ever look closely enough at what had actually happened during that funeral week to understand its full shape. They were right about the grief. They were catastrophically wrong about my capacity to eventually, patiently, rebuild myself into someone capable of examining that grief-shrouded week with total clarity, once I was ready. If you are currently grieving something significant, a parent, a relationship, any major loss that has left you temporarily unable to fully protect your own interests, and you sense, even faintly, that someone close to you might be taking advantage of that vulnerability, I want you to hear this clearly. Your grief does not disqualify your instincts. It may delay your ability to act on them immediately, and that delay is not a failure. It is simply the honest reality of being human during an acutely difficult time. But delay is not the same as permanent blindness. When you are ready, and you will know when you're ready, go back and look carefully at what happened during the period you couldn't fully protect yourself. You may be surprised, as I was, at exactly how much leverage remains available to you, even after significant time has passed, if you're willing to do the patient, careful work of understanding the true shape of what occurred. I also want to say something specifically about intellectual property and ownership documentation, because I think it's a practical lesson embedded in this story that extends well beyond my own specific circumstances. Never assume that operating a business under a piece of intellectual property is the same as that business actually, legally owning it. If you are ever building something valuable with family, with friends, with anyone, protect the underlying asset with the same careful documentation you would insist on with a stranger, not because you expect betrayal, but because the people who eventually betray you are almost never the strangers you were naturally cautious around in the first place. They are, overwhelmingly, the people closest to you, the people who had access to your vulnerability precisely because you loved and trusted them enough to let your guard down. My father spent a decade in a garage, trying to solve a problem that mattered to him, without ever imagining that the greatest threat to what he built would come not from a competitor, not from a failed experiment, but from his own daughter's husband and his own younger daughter, moving quietly during the 1 week he could no longer protect it himself. I think about that often, the specific, quiet cruelty of that timing, and I think, ultimately, the most meaningful response I could offer wasn't simply winning the legal fight, though winning mattered enormously. It was making sure that what he actually built, the thing itself, the technology meant to help people who badly needed clean water, survived the betrayal completely intact, and eventually reached exactly the people he always intended it to reach. That, more than the settlement, more than the equity, more than watching Desmond's confident certainty collapse across a negotiating table, is the part of this story I'm proudest of. I want to close with a few more specific reflections, because I think the practical lessons embedded in this story matter enough to spell out clearly, rather than leaving them implicit in the narrative alone. The first lesson is about documentation, and I want to be very specific here, rather than offering vague advice. If you are building something valuable, a business, an invention, a body of creative work, anything with real long-term worth, with anyone, including people you trust completely, ensure that ownership of the underlying core asset is formally, legally documented and assigned exactly the way a careful attorney would insist on documenting it for a complete stranger. Handshake trust, family trust, the trust of a marriage or a sibling relationship is valuable and meaningful in 1,000 ways. It is not, however, a substitute for a properly executed assignment document, a clearly written partnership agreement, or an updated will that accounts for exactly the scenario my father's estate unfortunately didn't fully anticipate. The gap that nearly cost me everything wasn't created by malice at the outset. My father simply never got around to the unglamorous paperwork, the way brilliant, focused people often deprioritize administrative tasks that feel secondary to the actual work they care about. That gap sat quietly, harmlessly, for years, until the specific circumstances arrived that made it catastrophically exploitable. Close those gaps before you need them closed. You will almost never regret the modest effort of doing so early. You may deeply regret leaving them open, waiting for a moment of crisis to reveal exactly how vulnerable they left you. The second lesson is about the specific danger of a single point of acute vulnerability, and how thoroughly some people are willing to weaponize it. I don't think Desmond woke up one ordinary morning and decided to become a person capable of exploiting his wife's father's death for financial gain. I think, more likely, the opportunity presented itself gradually, the equity restructuring conversation months earlier planting a seed, the funeral week arriving as an unplanned but irresistible window once it appeared, and Desmond's own character, whatever combination of ambition and moral flexibility already existed in him, filling in the rest without much internal resistance. I say this not to excuse what he did, but because I think it's useful to understand that this kind of betrayal often doesn't require a villain who has been secretly plotting for years. It sometimes only requires an opportunity, a moment of genuine vulnerability in someone else's life, and a person willing to prioritize their own advantage over basic decency when that moment arrives. Protecting yourself structurally, through documentation and clear agreements, protects you regardless of which category of person you eventually find yourself dealing with. The third lesson, and I think the most important one emotionally rather than practically, is about the specific relationship between grief and vulnerability, and how they compound each other in ways that are easy to underestimate until you've actually lived through it. I want to say clearly, for anyone currently grieving something significant, your emotional devastation is not a character flaw, and it does not make you foolish for extending trust to people close to you during that period. It makes you human, navigating loss the way any reasonable person navigates loss. If someone exploits that vulnerability, the moral failure belongs entirely to them, not to you, regardless of how thoroughly, in hindsight, you can identify the warning signs you missed while you were too devastated to notice them clearly. I also want to acknowledge something I've thought about often since all of this concluded. The version of this story that ends with me successfully recovering the company and the patent is, in an important sense, a fortunate outcome, dependent on a specific legal quirk, the unassigned patent, that not every person in a similar situation would happen to have available to them. I recognize that not everyone who is betrayed during a moment of grief has an equivalent piece of hidden leverage waiting to be discovered. I don't want this story to suggest that every betrayal like mine resolves itself neatly if you simply wait long enough and dig carefully enough. Sometimes the leverage genuinely isn't there, and the honest, difficult work in those situations is less about eventual vindication and more about the slower, harder process of rebuilding from genuine loss without the satisfaction of a clean legal reversal. I was fortunate that my particular circumstances included a path back. I don't take that fortune for granted, and I don't think it diminishes the difficulty of situations that don't include an equivalent path. What I do believe applies universally, regardless of whether a specific legal remedy exists in any given situation, is the underlying posture I tried to maintain throughout this entire ordeal. Patience over panic, documentation over pure emotion, and a refusal to let other people's confident certainty about having successfully outmaneuvered you convince you that their certainty is actually justified. Desmond was completely certain, for the better part of a year, that he had successfully and permanently secured control over something that was never fully his to take. That certainty, however confidently performed, was simply wrong, and it remained wrong for the entire year he acted on it, whether or not I had yet gathered the evidence to prove it. Confidence is not the same as correctness. Control seized through exploitation of someone else's vulnerability is rarely as secure as the person seizing it believes it to be, precisely because it was never built on a foundation solid enough to withstand real scrutiny in the first place. My father spent a decade in a garage trying to solve a problem that mattered to him, without ever imagining that the greatest threat to what he built would come not from a competitor, not from a failed experiment, but from his own daughter's husband and his own younger daughter, moving quietly during the 1 week he could no longer protect it himself. I think about that often, the specific, quiet cruelty of that timing, and I think, ultimately, the most meaningful response I could offer wasn't simply winning the legal fight, though winning mattered enormously. It was making sure that what he actually built, the thing itself, the technology meant to help people who badly needed clean water, survived the betrayal completely intact, and eventually reached exactly the people he always intended it to reach. That, more than the settlement, more than the equity, more than watching Desmond's confident certainty collapse across a negotiating table, is the part of this story I'm proudest of. Thank you for listening. If you've ever had someone close to you exploit your grief, your absence, or your vulnerability for their own gain, I'd love to hear your story in the comments below. And if there's one thing I hope you take from this, it's that patience, documentation, and a clear head, even when they take months longer than the satisfaction of an immediate confrontation, are almost always the sturdier path back to what's actually yours.